Virginia cannabis court interpretations are quietly reshaping how cannabis laws are enforced across the Commonwealth. Not through new legislation. Not through voter initiatives. But through court rulings that most Virginians never hear about until enforcement suddenly changes. Today, we are breaking down how Virginia cannabis court interpretations are influencing policy, enforcement, and compliance statewide, and why this matters for residents, patients, property owners, and local governments. Here's the context. Virginia legalized limited cannabis possession, but legalization did not end legal uncertainty. Instead, it shifted power into the courts. Since legalization, judges across Virginia have been asked to interpret unclear statutes, reconcile conflicting laws, and determine how older criminal codes interact with newer cannabis reforms. These interpretations are now shaping enforcement outcomes in Norfolk, Hampton Roads, and across the state, often without legislative updates to clarify intent. This is not about promoting cannabis. This is about understanding how the law actually functions in practice. Here's the legal explanation and how court interpretations work. Courts do not create law. They interpret it. When a statute is vague, outdated, or internally inconsistent, judges must determine legislative intent. Their rulings then become guidance for law enforcement, prosecutors, and lower courts. Virginia cannabis court interpretations typically arise from ambiguous possession limits, conflicts between medical cannabis statutes and criminal code, zoning disputes involving cannabis-related businesses, search and seizure challenges tied to odor or probable cause, local enforcement inconsistencies. Once a court issues an opinion, even at a lower level, it influences how similar cases are handled statewide. Here are some Virginia-specific examples. Virginia cannabis court interpretations have already impacted whether cannabis odor alone establishes probable cause, how personal possession limits are calculated, whether sealed containers matter in vehicle searches, how medical cannabis protections apply during traffic stops, what authority local governments have to restrict cannabis activity. In Hampton Roads, courts have addressed whether local enforcement practices align with state legalization intent. In Norfolk, interpretations have affected how police apply discretion in cannabis-related encounters. These decisions do not always make headlines, but they quietly reset enforcement norms. Who this affects? Virginia cannabis court interpretations affect more people than most realize. They affect medical cannabis patients who assume protections are automatic. They affect drivers who believe legalization eliminates search risks. They affect renters and homeowners navigating lease compliance. They affect local governments balancing zoning authority and state law. They affect law enforcement agencies determining lawful enforcement boundaries. Most importantly, they affect everyday Virginians who believe the law is settled when it is still evolving. Why this matters? When courts shape cannabis policy instead of legislators, the law becomes uneven. One jurisdiction may apply a narrow interpretation. Another may apply a broad one. That creates confusion, selective enforcement, and legal risk for residents who believe they are acting lawfully. Virginia cannabis court interpretations also signal where lawmakers may intervene next, either to codify rulings or reverse them. Understanding court trends helps residents anticipate changes before they happen. Scenario: imagine a Norfolk resident stopped for a minor traffic violation. The officer detects cannabis odor. The driver believes odor alone is no longer probable cause. But a recent court interpretation in a different Virginia circuit ruled that odor combined with other factors may still justify a search. The resident is now subject to enforcement based not on statute alone, but on judicial interpretation they never knew existed. This is how law evolves in real time. Hey, before we dive into this next part, I want to take a quick moment to invite you to join the Norfolk City cannabis community. If you're following Virginia cannabis law, policy updates, or local regulations, this is the place to stay informed and make sure you're ahead of the curve. We're also launching a newsletter that will deliver the latest legal updates, policy changes, and important insights straight to your inbox. It's completely free, and it's designed to help you stay up to date without having to dig through dozens of sources. So if you haven't already, hit that subscribe button, click the notification bell, and sign up for the newsletter. You won't miss a single update, and you'll be part of a community that's serious about staying informed. Alright, let's get back to where we left off. Additional scenario. Now consider a different situation involving housing and local governance. A Virginia renter lives in a multi-unit building in Hampton Roads. The lease was written before cannabis possession was legalized and includes broad language about illegal substances. The tenant assumes that because personal possession is legal under state law, the lease provision is no longer enforceable. But a local court interpretation rules that private lease agreements may still impose restrictions beyond state criminal law, as long as they do not directly conflict with statutory protections. And this is where it gets more complicated. As a result, the tenant faces a lease violation not because of criminal conduct, but because of how courts interpret the relationship between private contracts and evolving cannabis statutes. This ruling does not change the law on paper, but it reshapes real-world consequences for renters, landlords, and property managers across Virginia. Why this scenario matters. This scenario highlights a critical reality. Virginia cannabis court interpretations do not only affect police encounters. They also influence housing stability, contract enforcement, and civil disputes where many people do not expect cannabis law to apply. In other words, even when criminal penalties are reduced, civil consequences can still exist, and those consequences often come from judicial interpretation rather than legislation. What to watch next legally? Watch for appellate decisions that unify or split lower court interpretations. Watch for legislative responses clarifying disputed statutes. Watch for local enforcement guidance changing after major rulings. And watch closely for how medical cannabis protections are tested in court, because those cases often signal where Virginia cannabis court interpretations may be heading next. Question. Do you believe courts should have this much influence over cannabis enforcement, or should the General Assembly provide clearer statutory direction? Put your answer in the comments. Please like, comment, and subscribe for more educational videos on Virginia cannabis law and compliance.